Good afternoon, everyone. My name is Sandy Upchurch. I will be the mediator of today's Upchurch, Watson, White, and Max webinar. For those of you that are the hardy, you know that we had a crash and burn back in January through no fault of our own. Our Bright House connection crashed and burned twice during that, and we are still recovering from that. And it took a lot of courage for us to get back online today, praying that that wasn't going to happen to us again today. And it appears as though it is not going to be happening. We have approximately 110 people registered for today's webinar, so thank you all for joining us. And if you have any colleagues that you think might be interested in today's topic, please let them know that we will be posting the recording of Richard's webinar today on our website afterwards, and I'll remind you of that at the end. So a formal welcome to the Upchurch, Watson, White, and Max Mediation Group webinar entitled Mediation Insights for Litigators. What the heck is going on in the other room? Richard, I hear that all the time. You hear it too, I know.
All the time. It's a rare mediation where somebody doesn't ask me a question, along those lines.
The heck may change, but it's still, you get the gist of it. Co-sponsored today, co-sponsoring our webinar today, as always, is the University of Florida Levin College of Law Institute for Dispute Resolution. A big shout out to them. Robin and Jim and Deborah, a big thank you to all of you. Also, a reminder that today, which should have been in January, is the first of our annual series of webinars. We will be offering one a month. So for those of you that are following us, you have an opportunity to have at least 12 hours of CLE courtesy of Upchurch, Watson, White, and Max. Today's webinar is being offered by Richard Lord on the topic we've already gone over. Next month, Larry Watson will be presenting a topic entitled The Florida Litigators Dispute Resolution Toolbox. He'll tell us what forms of ADR are available to us and under what circumstances we should choose those options. In March, Rod Max will be tackling the topic of ADR in the context of class actions and mass claims. And in April, Michelle Jernigan is going to help you get into the brains of your client, whether you want to or not, and she's going to help you learn about how they make their decisions and what their brain is going through when they're trying to do some compromising and some negotiating. A few housekeeping matters before Richard gets started. If the slide you are seeing with our pictures, actually not with our pictures, with the title of today's webinar is not maximized, go ahead and do that so you can see the full benefit of Richard's wonderful PowerPoint presentation. This seminar or webinar has been approved for 1 hour of CLE by the Florida Bar. The course number will be provided at the end, and there will be a test at the end to see how many of you are listening and watching to actually write down that number. I get an unbelievable number of emails afterwards asking for that number. So let's try and keep that to a minimum if you can. But we will send it anyway if you ask. Lastly, go ahead and minimize that toolbox that you're seeing for GoToWebinar. There should be an orange arrow in your toolbox. If you click it, it's facing to the right. That will minimize that toolbar. And if you want to see the toolbar for some reason, you can send it off to the left, and it'll open back up again. If you do have a question, go ahead and send it in under the questions portion of that toolbox. We did solicit questions from you and I think we got probably 20 or 30, Richard, in advance of today's webinar. So we should be answering several of those during today's webinar. I think Richard is going to be responding to some of those privately and personally. This is part of the personal touch that we offer and that Richard's going to offer, especially for those participants today. And if you do have questions that you'd like Richard to answer offline, go ahead and send those in. We'll keep track of those, and Richard will get back to you sometime after today with those responses. So I've talked a lot about you, Richard. Let me tell them about you. Richard is a wonderful friend of mine, and he is a shareholder at Upchurch, Watson, White, and Max. Is that correct, Richard?
That's correct.
And you have been with the firm since 1999. Richard has a wide range of experience in mediation, including breach of contract matters, construction matters, medical malpractice matters, and so much more. And his topic today is really going to be helpful to all of us. let's go ahead and, Richard, get you started with your presentation today. And welcome. And I hope everyone can hear us just fine. We're already up at about 75 attendees out of 110 that registered. So our percentages are up, and everybody stuck with us. So thank you, Richard, for being here today, and thank you, everyone else. I'm going to pass it over to you.
Thank you very much, Sandy. Thank you, everybody who's listening in. I know that those of you who tried to listen in last month had a frustrating experience that Sandy's already apologized for, and those of you who didn't have the misfortune of having to listen to that and see that are lucky. Hopefully
it wasn't pretty.
No, it wasn't. It was not. I was talking in the dark for a while, and I think some people were able to hear me, but it was interesting kind of flying blind. And I think I was listening to the list of upcoming webinars, and there's going to be some overlap between what I touch on and what is gone into in a much more in-depth fashion with some of the other ones. The last one mentioned, Michelle Jernigan's, getting inside of our brains. I'm kind of very superficially touching on some of the things I think that will be, directly targeted by Michelle in that webinar. Mediators are asked all the time, and if not literally all the time, then quite frequently, things along the lines of what's going on over there, why is it taking so long, who's making decisions, how are they reacting to this, that, or the other thing, what is their demeanor? All of those types of questions are essentially, along the lines of what I refer to as questions about what's going on in the other room. And I've tried to take some of the more commonly experienced observations, if you will, to create the content for this webinar as modified by some of the questions that were submitted in advance. And I appreciate those of you who've submitted those, and hopefully we've covered some of that in these slides. I want to start with the notion that mediation is not a single discrete event. Settlement might be when we're actually writing our names to the piece of paper. Arriving at the actual arrival at the terms of the settlement, that might be a discrete event. But to get to that point, it's a process. And we've heard mediation described as a process, but it's not a process. It is many, many, many multiple processes that are under the umbrella of the mediation process. And some of those things that we experience are along the very topical level of the negotiation, the back and forth, the sharing of information, and the things that you would be able to have law students raise their hand to, in a classroom, and they'd say, here are the parts of mediation. I'm talking about the parts below that that might not be something expressly known or perceived, but are still just as valid, just as present as the easily identified elements of a mediation. We all have experiences as professionals. Our clients do, the lawyers do, the mediators do, any support staff, any experts, anyone who actually attends the mediation. We have experience as professionals in our sphere of influence, in our profession, in our occupations, or in our experience. We also have experience as human beings, and I'm not a psychologist, but we are formed at an early stage, and we carry with us predispositions, both through perhaps genetics and being human, but also through experience. And I think it's important for everybody to appreciate that all of those things that make us who we are going to potentially impact what we do in our individual caucuses with the other people in that room, and what we do between rooms. And that's a very important part of mediation that is not necessarily something everybody's thinking about when we, get together at the beginning and, we kick off the process in our opening session. The thing that people like to do in mediation is, you like to be able to, predict the outcome. You might not be able to predict the outcome, but you're going to start to make predictions in your own mind. You're going to be assessing prospects of success. You're going to have a feeling about how quickly things should go, or how much time should be spent doing X, Y, or Z. A lot of times what you predict will happen can be wrong, and if you're subconsciously or consciously predicting something will happen, you're going to be frustrated or disappointed if it doesn't. And I'll tell you that when you think things might not be progressing as expected, it's not uncommon for the other side to be viewing it as moving along as expected. Don't assume something is wrong because things aren't happening when you predict they will happen, or things aren't happening as you think they should happen. And that's just really, I think, what I would like to leave you with in this webinar is that there's a lot of stuff going on that we can't control, that we shouldn't ignore, that does impact how you feel about the process and how you react to what's going on in the process. There at the surface level, I've already touched on it, you have the negotiation. What's conveyed between the rooms that ultimately, hopefully drives the parties to that point where they can see a reason to keep going and to not easily disengage from the negotiation, and ultimately, hopefully, getting us to the point of a resolution. Under that, surface level, as you get a little deeper in the process of mediation, obviously there's going to be analysis going on in the other room, and a lot of times the kind of individual or human factors that I'm going to be discussing. I kind of like this slide that Kathy Klasny found to help me, put this PowerPoint together. It's a reef. It's complicated. A lot of parts, a lot of organisms, a lot of characteristics, and that's something that's there. You just have to dive a little bit deeper. To see them.
That's very poetic, Richard. That was a very poetic comment. Wow.
It might be. It might be.
I like it.
Thank you. Probably makes sense to half the people and doesn't make sense to the other half of the people, but that's okay. We've all heard the phrase, like peeling an onion. Sometimes issues, sometimes, looking or unraveling a legal problem. Peel an onion. But every person in your mediation is an onion with layers. You're going to have, the procedural posture of the case that, has layers. You're going to have the facts of the case. You're going to have the, the good, the bad, and the ugly of your case. And then you're going to have all those individual things. And because there are so many different, moving parts, a lot of times you'll have the flow of the mediation take unexpected, turns. Every layer comes from, the individual's experience, how they've mediated every other case, or how their family worked when they were growing up, or how their business works, or all those things that affect a worldview or their perspective, that we sometimes refer to perspective, or your orientation. It's going to all come from the layers that everybody brings to the table. And your mediator has layers too. This is just a slide to, say, hey, we're not dealing with one layer in mediation. If we have two rooms, we're not even dealing with two onions. We're dealing with, an onion representing every person who's involved in the process. And I want to also just say that sometimes it's a conscious thing that we have to deal with in dealing with the individual's layers. Sometimes it's subconscious needs. There's baggage. There's sense of identity or self-worth. Somebody's sense of competence. All these things that are going to impact how a person views things and how the person is impacted in terms of what they want to get out of a particular part of the mediation. All these influences impact what happens. Also, it's amazing. I think that there is very often more work done within a room than between the rooms. The lawsuit, the claim, the pre-litigated pre-suit matter being resolved in mediation. Obviously, the goal of getting something done is what happens between the rooms, but I find that the most important part of the mediation that allows you, in most cases, to make the kind of progress necessary to get cases resolved is what happens within the rooms. And that's probably something that is understood by many people who've done a lot of mediations. It's why things go longer. It's why they should go longer. It's why sometimes people find that they don't. And I'm just going to make reference to the fact that I have just moved to slide 11, and it appears to be blank.
If you go ahead and click it again, there you go.
And now it appears to be populating, which is very good. what happens between the parties? There's exploration, there's communication and sharing. There are decisions made about what we withhold or what we convey. You do have the obvious argument on legal points or on factual points or on the level of the significance of the factual points. You have also the negotiation that goes on between the rooms. That's an obvious part. You have things that relate to reconciliation and risk management and planning, and those are just some of the top-level issues and top-level events, if you will, and considerations that go on between the interests, between the parties, between the rooms. When you're actually in one of the caucus rooms, there are many more interactions. If I'm going room A to room B, there's one interaction between A and B. When you have a room full of people in room A, there are interactions between the people in room A that are going to drive the utilization of our time and energy. And you're going to have not only a debate about analysis between room A and room B, you're going to have debate and analysis within the room. Very seldom is there a single view of any point in a caucus room on behalf of one party. There is sometimes no consensus. There is sometimes a difficulty in reaching consensus. And a lot of times, you're going to have some level of posturing. Maybe there's a better, more diplomatic word than posturing to describe what's going on in a room, but sometimes there are people who have a different role in the company or a different role in the family, and there is a little push and pull between people who you would think are on the same side because they're in the same room, because they're identified with the same party. Expectation management is a huge part of what's going on in the other room in most cases too. Unless you have parties that are very well versed, very experienced in the litigation, dispute resolution world. When you have individuals who come from business or come from families, and they are in this case, and this is the first case they've had, or maybe it's the second one in 20 years, the expectation management that has to take place, even if it's been done, even if it's been commenced and started by the lawyers, before we all get together for the mediation, that is something that obviously has to happen and does quite frequently happen in mediation. Risk management, cost-benefit analysis, odds, discussion of odds, all of those things that you sometimes will think, well, gosh, shouldn't they have done that before they got here? And I'll get that sometimes in a mediation. I'll go into a room and I'll get a quizzical look about why it's taken so long, and I'll say that this, that, or the other thing is being dealt with or addressed, and sometimes they'll say, well, isn't that something that should have happened before today? I'll tell you, even if it happened before the mediation started, it needs to happen in the mediation for it to actually boil down to a decision being made. And sometimes the analysis that's done before the mediation is not going to be incorporating what you want it to incorporate to the degree you want it to be incorporated. And ultimately, it may never happen to the degree you want it to happen. But that's really on a different subject. One of the issues that I think makes the opening session so important is it's that opportunity to convey things that you think are critical to the other side's analysis. That opening session is going to give your mediator the fodder, if you will, to continue the discussion in private caucuses to help with expectation management and risk management. There are psychological processes conducted within the minds of every participant, mediator included, lawyer included, and those are things that perhaps Michelle will educate us a little more on later this year. There are logistical processes about how this is going to work, and sometimes it's an issue of communicating with somebody who's not physically present in the mediation. Sometimes businesses will come with a division of labor, and the person who has to be involved in decision making is not physically in the room, but they're available, and there are times when the process of communication does have to be extended because we have someone who's not in the room, who is necessary to the decision-making process, or who simply has to, acquiesce at the end or be okay with at the end what happens. Families sometimes present this as an issue too, when there's a very perhaps strong-willed or influential, brother somewhere, sister somewhere, spouse somewhere, and you have to make sure you have the blessings of the other members of your family before you agree to what you're proposing, let alone agreeing to at the end of the day. All these things impact the decision-making processes, which are complex. Sometimes the mediation is the first time, when there are like multiple lawyers involved, that a lawyer may be meeting a client. Sometimes it may be the first time the client has ever had an opportunity to have a little Q&A, a little question and answer session with their lawyer about what about this and what about that. That can add time, and that's the kind of stuff that sometimes people would think, well, that should have happened before today. But my point is this: if it hasn't happened before the mediation, you better be prepared to let it happen in mediation in order for the analysis to take place that has to take place. And a lot of times, like I've already touched on, it's the first time they've listened to your side of the case. There's also a lot of time spent on discussing how certain depositions might have gone. What did this person say? What did that person say? A lot of times the client will want to know who else can be deposed, and what evidence there is out there that might support a point or not support a point.
Richard, may I interject with a question?
Yes, please.
I was just wondering what your thoughts were on having these conversations with clients. I'm talking about the advocates, the litigators, having some of these conversations with the clients in advance, or does a lot of this just need to happen organically throughout and during the mediation?
I think having conversations in advance can help, but having conversations in advance cannot guarantee you won't need to have them again or different ones in the mediation. The context matters. A lot of times, I'll use a different example. A lot of times somebody will say, well, I would never consider that as an option. And yet when it's proposed as an option, and it might be one of a very limited number of options, they might consider it. So the context changes, the dynamics change, and I think if you're in the process, the throes of a mediation, sometimes even if you've talked about it before, you got to do it again. I would never discourage early conversation. I would encourage early conversation, but that does not guarantee you're not going to continue that conversation or start new ones when you're mediating.
All right, great, thank you.
Thanks for the question. I'm sure everybody was appreciative of the opportunity to hear somebody else's voice other than mine.
That's not why I did it.
Well, I'm sure, again, half the people probably appreciate it, and half the people, were probably liking the question just for the sake of the question. In any event, it gives us a little break. I'll tell you, and it's a good point for me to shift direction just a little bit. This webinar is not about emotional levels of grief, of things that might be how the brain is understood to process profound or significant emotion. But I'll just touch on some things. It is not uncommon for me in the types of cases that I mediate for people to have to, in a very compressed time frame, deal with not only legal analysis in an alien context, because they're not in litigation all the time, but they're dealing with their emotions that are obvious in terms of their origin. Let's say they've lost somebody, and dealing with a legal process that is alien, that requires you to be as objective as you can in your decision making, allowing for the possibility that somebody that has caused you, or at least was somehow connected to your understanding of why you've suffered this loss, having to work in a business-like manner while processing your own emotions about what might have led to what happened, that is a crucial and dynamic process that's not the subject of this webinar, but is something that people need to acknowledge can cause the ebbs and flows of mediation to be what they are in cases where those emotions exist. Sometimes people have to deal with the grief. Sometimes they have to deal with guilt. Sometimes they have to deal with blame. Sometimes people deal with principle, and it's hard to not acknowledge those things when we're trying to get something resolved in the mediation if they're present. So that's kind of why I believe that what's happening within each room could be the most important of all parts of the mediation, because it does affect the interactions between the rooms, and it does affect how the outcome is ultimately reached, and ultimately it does impact what the ultimate outcome is. And if you go into a mediation just understanding that there are going to be perhaps legitimate reasons that will cause things to wax and wane and ebb and flow at different points, you'll be less disappointed, less frustrated when you do, hit those points where things aren't going exactly as you think they should. Every context is different, every case is different, every person's different. Now, the clients come to mediation with expectations, and the attorneys come also with expectations. And this is kind of a little review. All of the clients and lawyers' expectations are influenced by their emotional makeup, by their sense of right and wrong or principles. It's all going to kind of be impacted by what the particular practicalities are of a situation. I think it's helpful if we can get people to be as realistic and practical as they can. Sometimes we want to use the phrase reasonable, but one man's practical is not going to sit squarely with somebody else's practical, and one party's or lawyer's view of reasonable obviously it will not sit squarely with someone else's view of reasonable. And pragmatic considerations are unique to everybody's own economic and structural organizational realities. So just understand these are all here. Risk reward considerations impact lawyers and clients. The personality drives a great deal of not necessarily the expectations, but of how the lawyer and the client. And I guess I could put another circle on this page, the mediator, because we're in that room and we're dealing with clients' expectations, and that's going to be something that's just as legitimate as counsel's, and vice versa. But the personality is going to kind of impact how those things are massaged or manipulated or managed. Everybody has formative experiences. Lawyers come to mediation having had great success doing things a certain way or taking a certain approach. It might be hard to get them to modify their approach, and that can impact what's going on in the other room, and it might cause things to not move as you wish they would. Everybody's history and experience, therefore, is important, and I've probably already said enough about psychology and perspective. Going to the next slide.
Richard, I grabbed that mouse for a second, so you need to grab it back.
I'm grabbing it back.
Good job. I love this diagram. This was so creative.
Yep, and I'm not going to take the credit for this. This is again Kathy Klasny, who makes us all sound and look better than we would otherwise. This is not an all-inclusive list. These are some of the basic and common questions. Some that are unspoken that impact how we feel about the process and prospects for success. A lot of this is, I think, derived from human nature. A lot of this is, sourced in our own experience of what's worked for us in the past. If we're thinking practically, we're going to be really looking at what's it going to take to get this matter resolved. And sometimes people want to know that. Sometimes I'll get questions along those lines very early in the process, and more often than not, it's too early to know. Because I tell people in mediation all the time, at the end of your mediation, you might be, making a decision that I use the phrase barely good enough in many mediations. You might be making a decision where you're white-knuckled, barely holding on to the idea of resolving it for whatever the potential resolution is, and you don't know what that's going to be at the beginning. In most cases, because the process is dynamic and you have to include what you don't want to include, but don't ignore things that might impact decision makers who aren't in the room yet. And also the other side might modify what they're ultimately doing because of what they might not initially want to include in their analysis, but through your your efforts in mediation, they ultimately do include in their consideration. So, and you want mediators who are doing, what you ask of them, and one of the preliminary things that one room might typically want to know what the other room is, is the other side here to really get it done, or are they just fishing? And again, I think sometimes it's premature for us to speculate, because I've seen things settle that early on looked like they wouldn't settle, and I've seen things not settle that, a quarter of the way through or halfway through, it looked like it would actually result in a resolution.
Richard, I want to let you know that we have a little bit of a conversation going on online on Twitter at #OtherRoom, OTHERROOM, and I would invite anyone who's listening right now who's tech savvy and loves Twitter to go ahead and tweet some questions, tweet some comments at #OtherRoom and join in the conversation.
That's a very good thing, and I appreciate you sharing that. So this was the slide before I clicked the slide advance button twice. Questions about authority, about obstacles, obviously are things that are commonly referenced, because one room will want to know that the other side, I think you want to know where you need to direct your efforts. A common question is also not as common as the others. Are we missing something? Sometimes it's not a question where you are asked to go in there and tell them what they're missing, but they just basically want to know if there's something that's being missed, and they might ask it directly in the form of a question: are we missing something? Or just it could be asked in the form of, how are they reacting to this, or what are they saying about that? And there's a slide later in this presentation where we do, remind all of you listening and watching that there are limits to what we as mediators can share and convey. So we do not have an unfettered ability to answer all your questions. We do have constraints, but a lot of times you can try to use alternate means to kind of figure out what's going on. Decision makers, who's making decisions, who's an obstacle, who's not. Those, again, like I said, are pretty common things that are of concern to people. And when we're in mediation, we're predisposed in some respects to want to try it a certain way first. You might want to do what's worked for you in the past. I've already mentioned that. Just because it's worked in the past and you've had good success with it, you might want to go that route first. Human nature sometimes drives us to look for concessions or look for new information being revealed before we share information or give concessions. And also, I think quite often people may not intentionally conceal their true analysis or bargaining posture, but perhaps withhold information that isn't necessary to be conveyed until it looks like it's necessary to be conveyed. A lot of times people, however, I think they might be in conflict. Only conveying what's necessary may not allow you to take no longer than necessary. A lot of times I think you might need to be wanting to convey more information to get the other side to think the way you think they should think a little more in relation to what your view is, to try to get it resolved. If you're getting information and sharing information, it's probably going to take a while. So try to go into mediation being a little more open about what you might share, and being a little more open to it taking longer. Needs, wants, and preferences are also something I'd like to talk about. I don't have those on a slide necessarily, but these are issues that go to what might be satisfied by getting a case resolved, and by looking at what a settlement or lack of a settlement might result in terms of satisfying your needs or your wants or your preferences. Those are things that are all important and may take time to work through in a particular room. Somebody may mistake wants for needs, and it might be that the case can only settle if with their needs being satisfied. And sometimes they don't even know what those needs are until we're in the mediation. Sometimes we're not even able to conceive of how we can help people satisfy those needs, or maybe once, until we have a concrete offer to think about and consider. Now, I said we have limits about what we can share, and there are ways also for you to find out what might be going on over there. You can also influence what's going on over there, and this kind of relates back to that last slide or two where I talk about being open, and maybe here you might want to think about not doing it the way you always have, and being perhaps less inclined to withhold or conceal a true bargaining position or posture for a while until you get a better sense of what's going on. So, don't be afraid to leave posturing behind sooner. Posturing just adds time to getting to the point of ultimately really getting a sense for how intractable or how close the parties might ultimately be able to be. Mediators make suggestions in mediation. We make them not to waste time. Mediation,
Oops, sorry about that.
That's okay. That's okay. Mediation is a time when the mediator should be perhaps making suggestions, and we're not making suggestions, again, that we think will waste time. It could be that we sense something needs to be addressed. It could be that we feel something can create more momentum toward resolution, and then another course of action could slow us down. So, I would just encourage everybody to be willing to try what your mediator suggests. If the progress is frustrating or if it stops altogether, I've seen people effectively say, you know what, maybe we come back with, different circumstances. We come back on a better day, or when somebody else can be here, or when we can do X, Y, or Z to increase the odds of reaching a meaningful resolution.
Richard, we got a question on this topic that I wanted to maybe throw out and have you and I discuss. The question that we received in advance of today's webinar was, do plaintiff counsel's arguments, really it should be, do counsel's arguments receive any consideration in the other room? And I wanted to offer some thoughts on it and maybe get some thoughts from you, if that's okay.
That'd be great, yes.
My thoughts on that, and I'd love to hear your take, is I do believe that that the attorney's arguments do receive consideration, especially by the other room's clients. I really do believe that for the most part the lawyers' ears are plugged up and they've got their mindset for the most part, but I think the clients are hearing new things, and it just takes time for things to be absorbed, and I do think that lawyers' arguments are being absorbed and heard by the opposing party. I also think that if you want to help your mediator get the message across, or a message across, perhaps the message is a great case that's completely on point, bring that case with you and arm your mediator with that so they can go into the other room and say, listen, I'm not an expert in this particular field, but I've been provided with this case. I've read through it. How are you going to respond to this at your summary judgment hearing? What's your position about this case? That kind of thing. If you arm your mediator with photographs or irrefutable things, and you send them in the other room with that, I think that's listened to, and I think that works. What are your thoughts?
I will say this: every point that lawyers make is different, and every lawyer is different. Every client is different. I believe, though, that the odds are in your favor, that your points are being heard. Obviously, in mediation, it is not uncommon for us to disagree about a multitude of things that would impact what we do in mediation, or what happens if the matter is adjudicated. Every time I walk into a caucus room, I'll assume, if there are two types of people in that room, a lawyer and a client, at least two sets of ears. Both of them hear what we convey. Both of them will if they're listening to what the mediator has said to that point in the mediation, hopefully allow for the possibility that the point being made could ultimately hold sway down the road. So I do think that lawyers' points, and I see it. I see clients look at their lawyer when the other lawyer's point is being made. I see lawyers not react, but but somehow acknowledge, the point being made. Very often, I will see lawyers jump into the breach and articulate why they have a different point sometimes, and that to me is evidence in most cases that the lawyer and the client hear it. If you want to know if your point is going to bear fruit, you're not going to know that till the end, and you might not even know it then, because if the case is resolved, you may think it's resolved because of your point, when in reality it's resolved by the other room focusing on something else. So I think it's important to try to make your points. Don't use mediation as just a way to throw numbers back and forth. Hire mediators that you think will make their best effort to convey what you want to have conveyed. And then if the case resolves, maybe it bore fruit. If the case doesn't resolve, it doesn't mean it didn't have an impact. Maybe it'll affect what happens down the road. That's a good question. That's a good question, and that is one of the questions we got that we didn't really develop an individual slide for.
I think that it falls into the Jerry Maguire category of, help us help you.
Right. And don't assume it's going to be a waste of time, and even if it doesn't feel like it a lot of times I'll walk back into a room and, the lawyer will say, X, Y, and Z. And they'll want me then to go explain X, Y, and Z and come back and have immediate capitulation on X, Y, and Z. Just because you don't get it doesn't mean it doesn't have an effect.
No, it's got to take some time to digest, absorb all those things. You're right.
Right. Let me say a few more things before I move off of this slide. Other things that I have seen done to influence what's going on in the other room is, potentially when it's counterintuitive to do what the other side has asked or proposed, do it. Credibly changing direction, credibly changing the topic, trying to narrow issues, perhaps, or maybe you're getting bogged down in making progress on the big issue. We'll try to reach some sort of agreement on the smaller or tangential issues. Try to talk about maybe achieving a resolution that's conditional or preliminary. Slamming on the brakes can cause the other side to slam on the brakes, but maybe you can slam on the brakes tactically to see what kind of reaction you get. Clamming up sometimes, just causes the other side to clam up, but you might want to decide if you're going to tactically do that. I tend to err on the side of opening doors and conveying information and allowing for possibilities rather than slamming on brakes and clamming up. And I always discourage ultimatums unless the ultimatum reflects something that actually really quite literally has to happen. A negative reaction in your room, following a negative urge can really cause the process to get derailed. And if the other side wants to frustrate you in hopes that you will negatively react, you might then be just falling into their plan. Somebody that doesn't want to make progress might take a really hard, tough position. And if you do what they might calculate you will do, they get their way. I also understand there's always a push and pull in a mediation regarding what do you disclose and what do you withhold for trial prep. You might have a sense that you have some knowledge advantage or procedural advantage the other side might not even be aware of. You might want to take advantage of that. Well, each room has to make the call on what they share and what they sit on. Not disclosing might push you down the continuum of dispute resolution away from a mediated settlement. So if you're sitting on something good, you're sitting on advantage, you don't share it, and you don't make them aware of it because you want to use it down the road. Well, down the road means you're not going to get your case settled. So it kind of helps, you're withholding because you're going to have to work down the road, become a self-fulfilling prophecy. You will have to work down the road because you won't be getting your case settled. If you want to save more information for adjudication, adjudication is likely what you're going to get with all the attendant, risks and costs of adjudication. The next slide, you're walking around the mediation center. You're asking for. Did you have something, Sandy? I'm sorry.
Is your slide moving forward properly, Richard? I want to jump in if it's not. Okay.
It is. the opportunity you have to influence what's going on in the other room is what I touched on the prior slide. Looking for clues is something else you can do. You can ask, questions. If you ask your mediator questions, again, we can tell you things we can tell you, but we can't tell you things that we, can't tell you. And just understand we do have constraints. You can ask other counsel questions, though, directly sometimes. You can make observations in terms of what everybody's doing and how everybody's doing when you see them in the public spaces of your mediation facility. You're going to ask questions, you're going to listen to your mediator, you're going to also be able to make your own observations. That's the point, that, I think you have all these avenues to try to figure out what's going on in the other room. And a lot of times just seeing progress, albeit small or frustratingly slow, from the other room might be the most revealing about what's going on in the other room.
Richard, I was going to interject with a couple of questions that we received from some registrants, but I would like to go ahead and give you a chance to get through to the end of your session, and if we have time at the end, I'll go ahead and introduce those questions then, if that's all right with you.
That would be good. That'd be good. This is something that I think is important, akin to my belief that what goes on in the caucus rooms is sometimes more important than what happens between the caucus rooms, because it's what allows progress to be made. Also, paying attention to what is unsaid is an important part of mediation. I think a lot of times we'll have a negotiation round where something is conveyed and something else is conveyed, and there are messages that are conveyed. I think it's really important to sometimes hear what's being said, understand what the message is, but also kind of look for what might not be conveyed, look for what's not being said. And I do firmly believe that sometimes the most revealing thing about an opportunity at a particular point in a negotiation is looking for what is unsaid. And here's the slide that refers to our limits. Information obtained during caucuses may not be revealed by us as mediators to any other participant in the process without the consent of the disclosing party. So if we're coy, if we're quiet, if we're evasive, understand there's a reason for that. You can ask us if we think progress is being made. Now, the mediator has the ability to make that observation based on all the moving parts, and your mediator may be and should really be the last one to lose optimism, and I think it's a fair question. We're not going to disclose a confidence by saying, yes, I think progress is being made, or I think progress is really hard to come by, or we're nearing a point where it's going to be hard to keep making progress. We can make observations like that, but just understand, if you ask certain questions, we might have to ask permission, and maybe you'll want us to ask permission to answer the question you've asked. Sometimes people ask a question of us and don't want the other side to know they're asking the question, so they don't want us to go in the other room to ask if we can ask the question. That was a little circular, but hopefully you understand what I mean.
I got it.
Good. So we're going to pay attention to what's said and unsaid. We're going to also, I think, make observations based on whether or not negotiations and the back and forth are consistent or not. Midpoints are rarely not observed in mediation when we're talking about discrete offers dealing with a number. More complex mediations where we're dealing with a lot of moving parts, elements of a deal, that's different. But when we're talking about monetary, numerical things, midpoints are looked at, even if you don't intend for the midpoints to mean anything for a while. Brake lights slowing down, and feeling that some steps are accelerating in terms of their frequency or pace. Those are all things that you can use to kind of assess whether progress is being made or not. You can read the tea leaves from these types of things, and it's just important to not panic when your expectations aren't being met, and don't panic when you see brake lights, and don't panic or become pessimistic when you see consistency go away and variability come in, or vice versa. Brackets, midpoints, not the core subject here, but midpoints can be a way for you to influence what's going on in the other room and learn what might be going on in the other room. Negotiation ranges can ultimately be created by competing or alternating brackets. And this is a review for people who've listened to negotiation and midpoint webinars before. I caution against viewing the first midpoint or an early midpoint, viewing it too heavily. It's possible, I think, and it's accurate to say that midpoints that are revealed later in the process or through more rounds of back and forth through brackets are perhaps more indicative of a true midpoint that might create a solution. I think it's a good idea also to understand brackets are simply, a partial offer to commit. They're only, an extension of a hypothetical. And I do think if you're in bracketing mode in the mediation, you want to kind of not mislead with your brackets, because you could get misleading brackets back. And I really think you create issues for yourself when you propose brackets where the midpoints actually move away from the other side. Now I know that we've had folks rejoin us, and I know that we have people on this webinar who were not involved last month, but we've left about 5 minutes, I think, for maybe an opportunity to address some of the questions that were asked, perhaps in advance or perhaps during the presentation.
Sure, Richard. I think we have time for one. I have 12:50, which is when we're supposed to end, but let me go ahead and get everybody to the last slide. So for those of you that do need to leave, there's the Florida Bar course number. Remember, this is a test for all of you. The Florida Bar course number is
new as of December 24th, 2015. The Florida Bar course number is 150898, N as in Nancy.
Go ahead and take note of that Florida Bar course number. And for those of you that can stay with us for one more question, Richard, the question I'd like to pose to you is, what is the best way to assess the other side's real position? I guess maybe their bottom line is what the question is implying.
I think I touched on this earlier about trying to, get too much clarity too early in the process of mediation. I think the efforts throughout a mediation are what are going to get you to understand or appreciate the bottom line. If somebody says, here's my true bottom line, here's my true top line, here's the extent to which I will not go beyond, if you get there too quickly, you may be getting a false indication. And I think it's the process and the back and forth and the trying to give the other side an opportunity to continue talking with you and the resisting of urges to stop talking. All those things are what allow you to ultimately get to the point of understanding, a true top or bottom.
Well, Richard, thank you. I'm going to go ahead and conclude today's webinar with a big thank you to all of our attendees. Another big apology to everyone who tried to attend back in January, and we had the technology gremlins following us. They were not with us today, thank goodness. I did not miss them. We are at the conclusion of today's Upchurch, Watson, White, and Max webinar, and we thank you all for attending. Make sure you write down the CLE approval number, and make sure that you go online to our website and figure out which of our future webinars you'd like to attend. I remind you that they are all complimentary as a service to our clients and future clients. And we invite you to send us any suggestions you might have regarding ADR-related webinar topics in the future. We'll do as many... Sure, go ahead.
Before we cut off, if I could just say one more thing at the end, just make sure you hand it back to me when when you're ready.
Oh, sure. Please visit our website at uww-adr.com. And a big thank you to, again, the University of Florida Levin College of Law Institute for Dispute Resolution. And to get real formal and technical, Richard, I'm tossing it back to you.
Thank you very much. I just kind of wanted to pull it together with one big takeaway. The other room may be waiting for you to signal that you're there to get it resolved. That goes to one of those slides earlier about what you withhold and what you do or what you look for before you do something. The other room may be trying to do it their way first and may need to try it their way first before your work ultimately starts to bear fruit. I just want to encourage you to be patient, assume the best, and let the mediator and the process keep working for you past when you think they should have to keep working for you. And just because things aren't going the way you think they should, it doesn't mean the other side won't ultimately be able to meet you somewhere and getting the case resolved. And when you're wondering what's going on in the other room, they're probably thinking or questioning and wondering the same thing about your room.
Thank you, Richard. And with that, from everybody at Upchurch, Watson, White, and Max, we say ciao for now.